I have to say that these sessions, which are devoted to national practice, which usually comprise of most of our trainings, but these traditional sessions about national practice are my favorite. Because it's indeed these moments we have to identify trends, identify pending challenges, identify good practices that we may or not replicate in other EU member states. And we have quite a few representation today here. So I think that this panel is very important in this regard. I would like to say the following, taking into account that this panel comes a bit in as a follow-up of the previous panel and in the sequence of what Madalena brought up. In what regards to the pact, I would like the speakers to take a little bit this in consideration. In our project, we're looking about on dialogue and on interaction, but we're also looking on the impact on practice, policy, and legislation. EU national legislation or EU national legislation or the pact won't be adopted in the void. So everybody's looking at us in a way. These negotiations will take very long. The case is now being pushed by NGOs, by legal clinics, by all sorts of organizations. Probably will have a very a heavy weight on how our member states will actually negotiate the pact. So I would like to leave this positive note, and I'm doing it now in the beginning because we're running a little bit late. So otherwise I will do it in the end. I'd like to positive note that, you know, regardless of our particular opinions or different applications of EU level case law, it is all in our hands. There will be a day where we will be negotiating article by article the pact in Brussels, and everything's open still. So without further ado, I will give the floor to Ana Rita Gil, which is assistant professor of EU law at University of Lisbon, but if I may, also former working for quite a few years in the Portuguese Ombudsman. And that will present Supreme Administrative Court cases, and very interestingly, a consultation by the Portuguese Ombudsman to the European Ombudsman on May 2020, and the decision is still pending. Ana Rita.
Thank you very much, Rita, for your presentation, and thank you for the invitation to be here. It is a pleasure to share with you some Portuguese cases as regards the implementation of the ACJ's NES case. Even though I do not necessarily agree, I have to say, as an academic, with their approach, I also take the opportunity to bring a different point of view, the point of view of the Ombudsman, which is also an institution that is made to defend the citizens' human rights and also foreigners' human rights. And without further ado, I'll share with you my presentation. So let me just, okay. I think, please tell me if you can see it.
Yes.
Okay.
Yes. So, yes, we can see it. Thanks
so much for the feedback. So I will focus especially on a specific question that has been, I may say, the main disputable issue in the Supreme Courts and also in the Ombudsman in Portugal, which is undoubtedly who has the burden of proof of a risk of ill treatment due to systemic deficiencies in the asylum procedure and also systemic deficiencies and also on the systemic deficiencies on the conditions of reception. I have here double the situation, I'm sorry. Both the courts and the Ombudsman has been dealt with this problem. Who shall prove that these systematic deficiencies exist? The state or the asylum seeker or refugee? So this has been the most disputable issue in Portugal. When we look at that, and this has been quite discussed today, to the ECJ's wording, the ECJ's wording claim that the member states shall not transfer the asylum seeker where they cannot be unaware of the systematic deficiencies. So, as we've been said, this does not raise a clear definition of who has the burden of proof. So it leaves the door open. It has been the door open in Portugal to some doubts of who may have this duty to prove. Also, as we say, we have also been talking about the CK judgment, and which has another wording, and says that it would be open to the authorities to dispel any serious doubts. Well, taking a look at this wording, one should think and one could say that it would be to the authorities to prove or to raise the question whether there would be a risk of ill treatment to the asylum seeker in the country which would be responsible for an asylum for analyzing the asylum request. So the case studies that I will bring to you, as Rita said, is one considering the Supreme Administrative Court. The first one was in 2020, but now we had a lot of other cases that followed the first landmark decision and have been repeated the same ruling again and again. That's something that happens a lot in Portugal. Once you find the first wording, the other cases, I have to say, unfortunately, repeat the first wording of the first case and the case of the Portuguese ombudsman. So, as for the first case that was analyzed for the very first time in Portugal, it was dated on January 2020. So it consisted on a case where the court had to decide a situation whereby an asylum seeker entered in Italy in 2016, has required asylum therein, and has moved to Portugal in 2018 and has requested a new asylum application. So, according to the Dublin regulation, Italy would be the responsible member state. So, procedure for take-back requests would be applicable according to Article 23 of the Dublin regulation. However, the applicant stated that he would not feel safe in Italy. So he would claim like a personal fear. Moreover, he also stated that he was in a refugee camp where he did not have access to the most basic health and hygiene care. So here it was a more general thing that he would claim concerned the refugee camp in general, in body. As for proving these applications, these statements, he presented several pieces of news published in national newspapers. Well, these pieces of news showed and presented evidences on bad conditions on refugee camps in Italy, and also that some refugee camps were being closed and refugees were being sent to the streets. So these were the evidence that were presented by the asylum seeker to prove and substantiate his fears of being ill-treated in Italy. Well, the administration, which in Portugal is the Aliens and Borders Service, claimed that this evidence was not sufficient to prove a systematic deficiency on the asylum system in Italy. So the applicant's statement, it said, and the pieces presented were not sufficient to demonstrate a real risk of ill treatment. And the thing is that in order to decide whether there was a risk or not, the Aliens and Border Service considered that these pieces were not sufficient and no further inquiries would be demanded from the Aliens and Border Services. So the Aliens and Border Services should not even start to analyze by his own motto whether there were any risk. So this is the thing that is important. The Aliens and Border Service did not analyze anything, did not proceed to any inquiries on its own motto. The Supreme Administrative Court has analyzed this situation and has decided the following. Has decided that only in duly justified cases where there are valid reasons to believe there are systematic failures in the asylum procedures, and such failures imply the risk of inhuman and degrading treatment, is the state concerned obliged to obtain updated information about the existence of the risk of the applicant to be subjected to such treatments. So the thing is, if the state is not convinced at the outset with the evidence presented by the asylum seeker that there is an actual and important risk of being subjected to torture, the state does not even start to analyze whether such risk may exist. So this is a problem. The state has to be convinced, according to the Portuguese Supreme Court, that such risk exists, that such risk may be sufficiently serious in order to start researching, to start finding proofs on whether such risk exists. So this is very demanding, this approach that the Supreme Court demands. So, and I think that, of course, in my opinion, as an academic, I think that the court has made a confusion here, because it has confused the exceptionality of the functioning of the exception of the Dublin regulation with the exceptionality of the burden of proof. Let me explain this. The exception to the normal functioning of the Dublin regulation stresses that only in extremely extraordinary circumstances may there be an exception to the normal functioning of the Dublin regulation. This is a very exceptionality demanding situation to the transfer rule. So the transfer rule is the norm, and the exception is to the risk of treatment. Only in exceptional and very serious circumstances can we find that there is a risk, and can we preclude the principle of mutual trust. This is one thing. The other thing is, when shall the state start to analyze whether this risk exists or not? We cannot demand that only when there are extremely circumstances provided by evidence shall we start to analyze. In my opinion, this is important for the state. Otherwise, the state puts itself at risk to be convicted for sending the asylum seeker to a country where he or she may face torture. So for the state to protect himself, once there is the minimum evidence of subjecting to a risk, the state must analyze. The state must seek for further information. But that was not the decision of the Supreme Court. The Supreme Court said the following idea: only in extremely extraordinary circumstances must the member state proceed to inquiries on the risk to ill treatment. So, since the applicant proceeded with these means of evidence, news that were published in national newspapers, and claiming mere risks or mere fears of not feeling safe, of a refugee camp that did not have access to the most basic health and hygiene. Well, the court considered that these were not sufficiently important evidence that could raise a risk of presenting of a risk of ill treatment, so no further inquiries would be necessary. So the Aliens and Border Service did not ask anything, did not even read reports of international organizations, of the High Commissioner for Refugees, so no evidence whatsoever was made by the Alien and Border Service. This is so that we can conclude that the Supreme Administrative Court gives an extreme prevalence to the principles of mutual trust and the principle and the importance of effectiveness of transfers from the Dublin regulation. So this is we can see when we are reading its decisions, it highlights over and over again that the Dublin regulation seeks to provide mutual trust and to enforce mutual trust between member states, and these are the most important principles of the Dublin regulation, and that must be enforced against all odds, and only in very, very exceptional cases must they be precluded. Further case law of the Supreme Administrative Court, so after this first case, have been repeated again and again these ideas. So this is the last case in May 2021, so it's very recent, and has repeated the same idea. The Aliens and Border Service is not obliged to make any inquiries, so any inquiries whatsoever, about the possible systemic failures of the reception system when there is no evidence that the interested party has been or will be a victim of them. In this case was especially shocking, I have to say, because the applicant claimed that there was a systemic situation, and the court actually agreed that there was a systemic situation, a systemic problematic situation on asylum conditions, and so. But the court said at the same time that although there was a systemic problems on the asylum procedures, the claimant has not proven that he would necessarily be a victim of these systemic problems. So this, in my opinion, goes completely directly against the spirit of the Dublin regulation and of the exceptional clause, and it raises me some concerns about where is the jurisprudence of Portuguese case law is going to. So it's getting worse. Just to finalize.
And Rita, I don't want to break your rhythm, but I have very strict housekeeping rules from Nicole. So 3 minutes. I'm sorry.
Yeah, just
thank you. No,
so
I don't.
As regards the ombudsman, just one idea, because actually it is not finalized yet. So just to know that also, as I said, the ombudsman is also an institution that is made for defending the human rights of migrants and asylum seekers. So we have a complaint of 2 Afghan citizens that has subsidiary protection in Sweden. And they made a second application in Portugal and claimed that they had completed 18 years old. And if they were sent back to Sweden, they would be sent back to their country of origin, to Afghanistan, claiming that once they stopped being minors, they would be returned. So as ombudsman, we have competence as well to deal with these issues. So what we did, we requested information to the Swedish ombudsman on the refoulement to the Afghanistan. This was quite disappointing because the Swedish ombudsman claimed that it was not aware of this practice, so it just it did not proceed with the collaboration with the Portuguese ombudsman. So we had to make a query to the European ombudsman asking whether what was the practice of the Swedish authorities. The query is still pending, but it was not made to the Swedish authorities, it was made to the European Commission, which is deciding who has the burden of proof, whether it's the Aliens and Border Service who shall inquire what is the practice of the Swedish authorities, or it is for the applicants to demonstrate whether the Swedish authorities make refoulement of Afghanistan citizens or not. So I will stop by now. So thank you for your patience, and that's all for the Portuguese case law.
Thank you so much, Anahita. I will now give the floor to Mohor Faidiha from Slovenia, teaching assistant at the Department of Constitutional Law. And again, I have to ask you to keep to the 15 minutes as we're running a bit late. Thank you.
Okay, thank you, Rita. Thank you, Professor Lazzarini, for inviting me. And I would like also to thank all the speakers of today, because it was really interesting to listen to you, and you gave us a lot of food for thought, as it was already mentioned. I'm honored to be able to be here and to present you the decision of the Administrative Court of the Republic of Slovenia concerning pushbacks from Slovenia to Croatia. This case is actually available also in the CGC database. I prepared an analysis and a summary that you can find online, but I have to add a caveat here, because the summary and the analysis is not entirely up to date, because after it was written, it was actually the Supreme Court quashed the decision of the Administrative Court, and only like 2 or 3 weeks ago, the second Administrative Court's decision has been now upheld by the Supreme Court, and has thus became final. But nevertheless, both the first and the second decision of the Administrative Court are more or less the same. So you can find the summary and the analysis useful. So now this turns me to the question, why am I going to present this case to you today, and why it merits your attention? I think there are many reasons, but mainly maybe I can expose 2 of them. First is the fact that the Administrative Court deals with many very interesting issues that are relevant beyond just the concrete case. For example, it deals with the relationship between the European Convention of Human Rights on the one side and the European Charter of Fundamental Rights. And then also, for example, it deals with the question of applicability of the Charter of Fundamental Rights, which is also always a very interesting aspect. But moreover, it's really an inexhaustible source of EU and ECHR law standards concerning the right to asylum, the prohibition of collective expulsions, and the principle of non-refoulement. And I will discuss only this principle of non-refoulement today, especially in connection with the principle of mutual trust. Why mutual trust is applicable, of course, because I'm going to talk about transfers from Slovenia to Croatia, and Croatia is, of course, an EU member state. The problem in this case was that there were some reports testifying about systemic deficiencies in Croatia, namely that the Croatian police were beating and brutally apprehending migrants. that were returned from Slovenia to Croatia, and that the Croatian police was actually pushing further back the migrants to Bosnia, and there was a risk that they would suffer inhuman or degrading treatment in Bosnian refugee camps. But before I go really deeply into the case, I would like to point to the second reason why I think this case merits your attention, and it was actually put before us by Judge Boštjan Zalar today already, and this is because the administrative court actually took the approach taken in the NS judgment and other cases concerning the returns are under the Dublin regulation and used it in a case of return under the return directive. Actually, it found that the presumption of compliance is rebuttable also in the context of returns under the return directive. So this can be seen as a novelty if we compare it to the case law of the European Court of Justice. But before I go into this analysis, I would just like to give you to explain how Slovenian side tried to justify its pushback practices. Well, Slovenia relied on Article 6, Paragraph 3 of the Return Directive, according to which a member state may not issue a return decision if a third country national illegally staying on its territory is taken back by another member state under a bilateral agreement, and this other member state then issues him a return decision. So Slovenia was basically claiming that this person that came to Slovenia did not express his wish to apply for asylum, hence he should be treated as a third country national illegally staying on the Slovene territory, and that Slovenia was merely acting in compliance with Article 6, Paragraph 3 of the Return Directive when it transferred this person under a bilateral agreement to Croatia, and that it was up to Croatia to issue him a return decision under the said article of the Return Directive, and that Slovenia was should have and did also trust Croatia that it will comply with its EU obligation and especially EU fundamental rights. Well, the court was not, of course, satisfied with this blind trust approach, and as I already mentioned, it held that the presumption of compliance should be rebuttable also in the cases of returns under the Return Directive. So now maybe it's a good idea to present what was the argumentation of this transplant of the NS approach to the returns under the Return Directive. So first, the administrative court relied on the case already mentioned today many times, Java, and paragraphs 88 and 89, where the ECJ says that the aim of the common European asylum system and the mutual trust is to guarantee that the application of that system will not result at any stage and in any form in a serious risk of infringements of Article 4 of the Charter. And as a result, according to the European Court of Justice, it is immaterial at which moment in time the person would be exposed to such risk, whether it would be at the very moment of the transfer, during the asylum procedure, or after the end of such procedure. So the argument, at least as I understood it, went in this direction, that if the Return Directive is a part or at least connected to the European Common Asylum System regulatory framework, and then this must mean that the aim of the Return Directive is also to ensure that member states do not blindly follow the mutual trust, but that they make a serious scrutiny of potential human rights violations. As an additional argument, the administrative court said that basically that if the presumption of compliance should be rebuttable in cases of returns under the Dublin regulation and returns under the European arrest warrant, it should be rebuttable also in cases of return under the return directive. And in addition to those arguments, I would like to express another argument that is not maybe so clearly visible from the decision, but I think it's very useful and interesting because it links directly this case to the cases concerning the returns under the Dublin regulation. And the argument is the following. This person came to Slovenia and requested the asylum for multiple occasions, but was ignored by the Slovene police. So actually, the Slovene police should have registered him as an asylum seeker, and if they had done so, the only way he could be transferred to Croatia would be under the Dublin regulation, and hence the rebuttable presumption would of course apply. So it should apply also in this case, because otherwise we would actually allow the police to benefit from its own doing, and this would of course be contradictory. So the standards from the NS and other cases from the Dublin regulation were found to be applicable. So the remaining question was how to apply them in the concrete case. Well, the administrative court first of all stressed that in principle Slovenia has to presume Croatia to be compliant with the Charter of Fundamental Rights, but in exceptional circumstances such obligation to presume is not applicable. So which are those exceptional circumstances? The administrative court explained that they arise when Slovenia cannot be unaware of systemic deficiencies in Croatia that put at risk the person transferred there, that he would be tortured or apprehended brutally, or I don't know, he would suffer inhuman or degrading treatment. So first, the administrative court had to ascertain whether the Slovene authorities could not be unaware. And what they found the administrative court found that there were multiple NGO reports from intergovernmental organization, international organization that were testifying of pushback practices in Bosnia, of untenable situation in Bosnian refugee camps, as well as about Croatian police brutality. And the administrative court also found that an NGO actually wrote to the Slovene police saying, look, what is happening in Croatia and in Bosnia, and the Slovene police actually replied. So it was clear in this case that the Slovene police was aware, or at least could not be unaware, of systemic deficiencies existing in Croatia. So it should have verified whether there is a risk due to, of course, first some generalized deficiencies in Croatia, and second, also for the person at hand if he would be transferred to Croatia. But the police actually did nothing. This is, in the end, the manner how the pushbacks work. So the administrative court found a violation of the procedural aspect of non-refoulement. So to conclude, this outcome of the case is, of course, firstly very important for the person at hand, who will now be able to enter Slovene territory and request asylum. Secondly, it's important for us because we're discussing today, and I'm discussing the fact that there is a new situation at which the mutual trust must give way to human rights protection. And third, I think it's also and predominantly important because it's a sign that we're maybe, just maybe, one step closer to the fact that one day the illegal pushback practices on the Balkan road will be over once and for all. Let's hope for this. Thank you very much for your attention.
Thank you, Mohor, and thank you for ending on that positive note. I will give the floor to Alexandra Favi, researcher of EU law, University of Florence, and she will talk to us about French case law. Thank you, Alexandra.
Thank you, Rita. Good afternoon to everyone. Just a second, I present my slides. Do you see it?
Yes, Alessandra.
Okay, perfect. So, okay. Good afternoon to everyone. In my presentation, I will deal with several judgments delivered by French administrative courts of first and second instance between 2017 and 2020 concerning the transfer by French authorities of asylum seekers to the responsible member states according to the criteria set out in Dublin regulation. These cases sketch the approach adopted by these domestic courts when dealing with the suspension of a Dublin transfer to another member state on grounds of the risk that the asylum seeker would be returned to his country of origin, where he would run a real risk of suffering torture or inhuman or degrading treatment, the so-called indirect refoulement we already seen with the Italian reference for preliminary rulings. For this reason, we can refer to an approach of the French courts going beyond the case law of the Court of Justice, since in these domestic cases, the existence of a real risk of violation of the prohibition of indirect refoulement derives neither from the systemic deficiencies in the responsible member state, nor from the applicant's particular situation. The circumstances which gave rise to these judgments are very similar. In essence, these rulings concern several Afghan nationals who lodged an application for international protection in France. The competent administrative authorities issued a decision ordering their transfer to another member state, identified as the responsible member state according to the Dublin criteria. In that member state, however, the asylum application of the Afghan nationals had already been processed and rejected. The Afghan nationals then appealed the transfer decision before the national courts, arguing that if they had transferred to the responsible member state, they would have been returned to Afghanistan, where they would have run a real risk of suffering torture or inhuman or degrading treatment. In some of the judgments analyzed, the French courts annulled the decision ordering the Dublin transfer and held that the administrative authorities did not correctly apply the Dublin regulation, notably its Article 17. As already said, this article provides for the possibility for a member state to process an application for asylum, even if it is not the competent member state according to the criteria set out in the Dublin III regulation, the so-called discretionary clause. In the other judgments analyzed, taken into consideration, namely the one issued by the Administrative Court of Appeal of Bordeaux of April 2018, the one issued by the Administrative Court of Lyon of September 2020, and the one issued by the Administrative Court of Appeal of Paris of May 2021, the national courts dismissed the appeal brought by the asylum seekers, notably on the grounds that the responsible member state had adopted only a decision rejecting the application for international protection lodged by the applicant and not also a return decision. Therefore, according to the Administrative Court of Appeals, there was no evidence that the responsible member state would have returned the applicant to his country of origin. I will then analyze the different judgments, taking into account four horizontal aspects, four horizontal issues. Firstly, the legal sources referred to by the French courts. Secondly, the assessment of the risk of breach of the principle of indirect non-refoulement by the French courts. Thirdly, the burden and the standard of proof required to suspend a Dublin transfer in these cases. And finally, the legal consequences of such a ruling for the asylum seeker and for the member state, in this case, France. Concerning the legal sources referred to by the French courts mention in their reasoning several sources of protection, notably the French Constitution, Article 3 of the European Convention on Human Rights, the Dublin III regulation, and the French Code of Entry and Stay of third country nationals and of the right to asylum. However, the national courts limited themselves to the quotation of the relevant paragraph of national, international, and EU law provisions, without any references to their different legal status or rank. The Charter of Fundamental Rights is only cited amongst the other legal sources, without specifying which provision could be relevant for the resolution of the cases. Only in the judgment issued by the Administrative Court of Appeal of Lyon of September 2020, the National Court expressly mentions Article 4 of the Charter in order to provide a legal basis for its findings. Moreover, in these judgments, no reference is made to the case law of the Court of Justice. As regards the assessment of the risk of breach of the principle of indirect non-refoulement, in the judgments where the national courts have recognized the existence of such a risk, the first element which emerges is that the French court's reasoning is mostly dedicated to examine directly the situation existing in the country of origins of the applicants, namely Afghanistan. To assess such a situation, the national courts take into account several international sources, notably the annual report of the UNHCR concerning Afghanistan and the United Nations Security Council resolutions. At the same time, the French courts do not verify whether the examination of the asylum application carried out by the competent member state is consistent with EU law, notably with the criteria set out in the qualification directive. In particular, it appears that whether a member state tends to return a third country national to a particular third country is not an essential element in the reasoning of the French courts. The second element that emerges from the French judgments is the fact that the French courts verify the nature of the decision taken by the responsible member state concerning the first application for international protection lodged by the applicant. In particular, in the judgment of September 2020 issued by the Administrative Court of Appeal of Lyon, it appears that to prevent a Dublin transfer, it is necessary a final decision rejecting the application for international protection and a return decision which can no longer be appealed, issued by the competent member state under the criteria set out in the Dublin III regulation. As regards the standard and the burden of proof concerning the suspension of a Dublin transfer in these cases, it is worth noting that the reason of such a suspension should in principle rely on the tendency of the first member state to return Afghan nationals to their country of origin. However, no particular relevance is given to how it should be proved, such a tendency. By contrast, it emerges from the judgments that it is up to the applicant to prove the final nature of a decision rejecting his application for international protection and the existence of a return decision, which can no longer be appealed, is issued by the competent member state under the Dublin regulation. In that regard, while the national administrative authorities have an obligation to cooperate in order to find the relevant information concerning the nature of the decision adopted in the competent member state under Article 34 of the Dublin regulation, as expressly stated by the Administrative Court of Nantes in its judgment, such an obligation does not seem to emerge as regards the judicial authorities. Finally, concerning the consequences of such rulings for the applicant and the member state, the French courts found that the administrative authorities had not correctly applied Article 17 of the Dublin regulation. This means that, according to the national courts, the administrative authorities should have recognized their competence and examined the asylum application of the Afghan nationals on the basis of the discretionary clause provided for by Article 17 of the Dublin regulation. Some conclusion can then be drawn from the above-mentioned judgments. Firstly, the boundaries of this new exception to mutual trust, which seems to emerge from these judgments, are still unclear, in particular as regards the relevant elements which must be taken into account in order to suspend a Dublin transfer. On the one hand, it seems necessary both a final decision on the application for international protection adopted by the first member state and a return decision which can no longer be appealed. On the other hand, the scope of the assessment of the risk of indirect refoulement in the responsible member state is still vague. The national courts seems to substitute their examination of the situation in the applicant's country of origin to the one carried out by the responsible member state. However, no particular relevance is attached to the assessment of the tendency of this member state to return the applicants to their country of origin. Furthermore, the burden of proof and the role of national courts in collecting evidences relating to the risk of indirect refoulement in the responsible member state is also unclear. In particular, while the Dublin regulation provides for a duty to cooperate between national authorities of different member states in the exchange of information, there is no mention of such a duty for judicial authorities of different member states. This may lead to some difficulties for national courts in knowing and assessing the praxis and tendencies of a member state to return an applicant to its country of origin.
Alexandra.
In conclusion,
sorry.
I will conclude. Yes, sorry. What seems to prevail in this case is a spirit of distrust between national authorities of different member states. In fact, the premise of such an exception to mutual trust in the context of Dublin transfers appears to be the fact that national courts of a member state no longer trust the assessment of the asylum application made by different authorities of different member states. Thank you for your attention.
Thank you, Alexandra, for your presentation. I would like to ask very quickly if there are any questions. Nicole, can I ask you maybe or Alexa, to read out the question that is in the chat, because for some reason I cannot see it. I think it's from Luminita.
Yes. What about the principle of equality of arms, an asylum seeker against an EU member state? It doesn't seem fair play.
Does any of the panelists want to take the question?
I think that the question is for me. I think that it is related with the Supreme Court of Portugal case law, and of course that I completely agree with you, especially because when we are dealing with the qualification directive case law, the sharing burden of proof is applicable. So I think that the same rule should be applied to Dublin regulation case law. So the Portuguese courts, when they are dealing with proving whether a person is a refugee or not, they apply the shared burden of proof. So the applicant can claim, well, I'm being persecuted, and then the authorities should research for the situation of the country of origin. So there is a shared burden of proof which is used and recognized by the Portuguese courts. But suddenly, in Dublin cases, they forget this practice, and they consider that what I said, that the applicant has to make a serious effort to prove that there is a real and serious risk of being subjected to torture, and only after that shall the administration be obliged to seek further evidence. So I completely agree with you, and I think that this case law is profoundly unbalanced.
Thank you. Any further questions? No? So in that case, I have to thank our panelists, Ana Rita, Mohor, and Alexandra, for your interventions. It was definitely very interesting. And again, everything's out in the open and every case counts. I will give directly, because we're running out of time, I'll give directly to the floor to Carolina Podstavam, lecturer in the European Union Law, University of Maastricht, for the final session. Thank you so much.